Okay, let's go on the record on DC 23-16933. Shields versus Hernandez. Counsel, make your appearances.
William Alexander on behalf of the defendant, Your Honor.
Catherine Wakowiak for David Common Associates on behalf of the plaintiff.
All right, we've had a discussion kind of off the record. I mentioned my court reporter had a doctor's appointment she had to go to this morning. The parties have agreed that we will, and we are currently on YouTube, that we will have the YouTube video available for the court reporter to transcribe if need be. And she doesn't need to be here live, that she can transcribe it from the YouTube video. And I understand that's agreed to by both parties. Is that correct?
That's correct, Your Honor.
Yes, that's correct.
All right, thank you, guys. So let's go ahead and get started. Go ahead and get started.
Sure, Your Honor. It's a defendant's motion to set aside a default and grant a new trial. We filed a motion, filed our motion a couple of weeks ago. We did attempt to contact the plaintiff's counsel to see if they would agree to it, but we were unable to connect with each other. The basis for the motion is that essentially they were attempting to serve my client at a wrong address. He was in a previous lawsuit with the plaintiff in another court. The plaintiff in this case is actually a defendant in the other one and settled out in the previous case. It's a car accident where 3 people were involved, and my client and the plaintiff in this case were both defendants in that action. In that previous lawsuit, my client gave a deposition and stated his address is 1810 John West Road in Dallas, Texas. If you go through the motion that we filed in the exhibits, you'll see that they were trying to serve him at 1820 John West Road. They also tried to serve him at 2522 Rand Street in Fort Worth, and they also tried to serve him at 4700 Wilmington Way in Dallas, Texas. I'm not sure where those other 2 addresses come from. Anyway, so that was error number 1. I guess the second error is that after they did file the motion for default, the plaintiff's counsel did try and contact me, but they're trying to serve me in at the law firm and the email address that I had in the previous lawsuit. They're just trying to serve B. Anderson at andersontruitt.com. The actual email address where I'm at is balexander@kpalawfirm.com. So eventually that email that was sent to the old email address got to me. We saw the motion for default. I attempted to contact the carrier to see if, tender the defense and get permission to answer. That for whatever reason, the adjuster was out for a couple of days and didn't get my email. Gave me permission to answer. I went back with that. I went onto the docket and I saw that they had actually entered the default against my client. I attempted to contact plaintiff's counsel to see if they would set that aside and let me answer, and we weren't able to get a hold of each other. And then I guess the other things to bring up is that I guess technicality, your order allowing substitute service at the wrong addresses, so that they're supposed to both personally serve and leave a copy of the default or the substitute service order posted at the address. They just posted the address. They didn't actually serve a person with it. So that was our third issue with that. So I guess factually, Your Honor, we think, one, they didn't comply with the order, and 2, we think we comply with the CRADIC standards showing that a mistake and an accident occurred. Several did actually in this situation. Factually, we think my client has a meritorious defense. The police report that we attach as an exhibit, and the actuality that they served or settled out in the previous lawsuit shows that, you know, there's at least some comparative negligence on the plaintiff's part. And then I guess the third standard for the Craddock is to show that there's no injury to the plaintiff. There isn't any injury. The default just occurred. And in actuality, it's better off for them to actually have some money to collect, since insurance is now available. So, and I guess the last thing is, you know, make an equity argument. The fairness, you know, is no fault to my client that they didn't get served here. When he did find out about it, we attempted to do everything we could to remedy the situation. And he does have a meritorious defense that he'd like to present to a jury. And I guess the other thing is there's been no opposition filed. I don't know if plaintiff's counsel is opposing this or not.
Response?
Yes, I'd like to go ahead and respond to all the issues brought up today. As far as serving, we did attempt to serve at multiple addresses. We believe defendant was avoiding service. We did attempt to send it.
So I guess my question is, I hear that all the time, and that can be very have merit in a lot of cases, but you had an address, as I understand it, from the other case. Why didn't you use that address?
We did use an address. It was similar to that in the same apartment complex. We went to the apartment management, asked if the defendant did live at that address, or in the apartment complex at all. They said no, he did not live. He and his mother, or his mother,
did you have an exact address from the previous, like the apartment number as well from the previous one? Why didn't you try to serve there? You said a similar address. Why not serve at the exact apartment from the previous one?
Because we did not have the 1810. We had 1820 John West Road. And when we went to the apartment complex, they said that neither the defendant or his mother still lived there. They had moved. And so we did find an additional address filed by
Mr. Alexander. Did your client move from that previous address?
My understanding is no, he didn't, Your Honor.
Okay. And was there an effort to serve at that particular? Maybe I'm just not understanding the exact fact. So there's a previous lawsuit. What was the address, Mr. Alexander, that came up in your client's, that was given to your client's previous?
Yeah, in the previous lawsuit, he testified that his address is 1810 John West Road. And
is that an apartment that has apartment numbers with it, or is that a single address?
That is an apartment address.
So did he?
I don't have the apartment number handy, actually, Your Honor, but
was the apartment number ever provided to plaintiff's counsel, I guess is what I'm trying to get at.
I'm not sure if it was or not, Your Honor.
In the previous case, I guess. Yeah, I hope you understand what I'm trying to get at, which is if she had the exact address on where to serve and she didn't try to serve at that, that's kind of game over. We just need to grant the new trial. That to me is very important. If she didn't have the exact address, then we probably need to hear some more arguments. So did she have the exact address from the previous lawsuit or not?
Well, I would have to go back and look at the petition and the service in the previous lawsuit. But he did appear in that lawsuit based on getting served at 1810 John West Road. They should have had access to the petition and the certificate, or the citation and proof of service in the previous lawsuit. And they also had his deposition testimony that he said 1810 John West Road. And the question attorney didn't ask, you know, is that apartment? What's the apartment number? But it should have been available to him.
All right, let's keep arguing here. So go on.
We did go to the apartment manager. We were told that the defendant and his mother did live at those apartments and they moved. We found a new address due to another petition filed by State Farm against defendant. They served defendant at that address by substitute service. We attempted to serve defendant. We were not able to. And then we were informed that he lived at that address. And so we did receive an order for substitute service, which mentioned that that the petition and order attached with anyone 16 or older at the location specified in the attached affidavit by securely posting the same wrapped in plastic to the door, which we did.
Okay. Did you have anything else?
I don't have anything else.
So what I typically do in this type of situation, if you had served at I'm a little unclear whether or not you had the exact right address. So my first thought is what I usually do in this is that I'll grant the new trial, but I'll require the defendant to pay the plaintiff's attorney's fees for getting the default judgment. Case law that supports that. Mr. Alexander, what is your view on that?
Well, Your Honor, I guess I would oppose that in the sense that we aren't showing any fault on the defendant for this having occurred. We made a good faith effort to comply once we found out about this, and I don't think there's any evidence to support something like that. But if it happens, if we need to pay that to set aside the new trial, we would do that.
So you're reluctantly agreeing to it, it sounds like. All right, how do you feel about that, Mr. Poviak?
Well, we were actually wanting the default to stand.
I don't know that that would stand up on appeal, given some of the issues in this case. I think the smart thing for both of you to do is, and usually it's about 1,000 in attorney's fees or 2,500, somewhere in that range. Doesn't sound like there was a lot done on this, so maybe agree to $1,000. That granting the motion for new trial based on the payment of $1,000 in attorney's fees. And then I also want to talk about if this is the right court to be in, but I want to get this first issue worked out. So does that work for both of you guys?
We can go ahead.
Yes, I can agree.
Okay, good. All right, so let's talk about this. Who was the judge in the previous case?
Oh, gosh. Let me see if I can find it was in the 44th District Court, Your Honor.
44th. I mean, and that case was filed first, right?
Yes, and it's resolved. It's dismissed, Your Honor.
I mean, I don't have a strong opinion. I think technically under the rules, that it should go to, are they wanting to get married? Yeah, just help them to come on in. I'll be done with this hearing in a few minutes.
Yeah. I told them they just have to go get their their outfits.
Their outfits, okay. All right. You know, technically that was the first filed case. It should probably go back to the 44th. But I'll leave that up to y'all if you want to file a motion to transfer. It's not going to hurt my feelings. But I think technically under the rules, that was the first filed case. So anyway, just something to think about. That's probably appropriate in her court since she had the first case. That's at least how I would look at it if I was in her situation. So do you want me to talk to her about that, or do you want to file something, or kind of how do you want to deal with that issue?
I'd probably oppose it, Your Honor. That case was resolved about a year ago and it's been dismissed. The plaintiff paid in that case. I paid in that case. We're ready to go in this court.
All right. Well, you guys talk about it. I don't really care. But if either side wants it to be transferred, then it would be ultimately her decision, not my decision. So if you want to file a motion to transfer, you might want to do that in her court. If you want to, if you don't want to, that's fine too. Anything else? And you guys need to be set for trial now. When do you guys want to be set for trial?
Let me pull up my calendar here, Your Honor.
The case is a little bit older, so you're going to get set for trial relatively quickly. So April, May, probably of next year is what I'm looking at.
I'm open on May 5th, Your Honor. I'm open also on April 14th and June 9th.
What is your?
Oh, later would be better for us, May or June.
All right, so what was the May date? You said May, does May 6th work?
May 5th would work, yes.
Well, we start trials on Tuesday, so May 6th work.
Okay.
That works?
All right, and then who do you want to use as a mediator?
Lexa All, Gary Berman.
Lexa is fine.
Okay. Ron, did you get that? Rhonda, did you get that?
The trial is set for May 6, 2025, and the mediator is gonna be Lexa All.
Yeah.
Got it, okay.
Anything
you.
else? Anything else we need to chat about, guys?
I don't think so.
Dog
That's it,
Tanner?
Your Honor. That's it.
You guys have a great rest of your day.
You too. Thank you.
Yeah. All righty. You guys are here to for a waiver, I think is what they talked about. Is that right? Okay, why don't you guys come on up? All right, Nico, can you take this back? All right. Here. And what about the other couple? Are they going to change? You said, right?
Yeah, they're calling, man, just want to make sure. Everybody sent it to your board.
I guess so. If I'm here, I guess they sent them to me.
Oh,
Well, good. That I was here for you. All right, so you just got to say how long have y'all known each other? 20%. Okay, you didn't just meet downstairs or anything.
Oh, no.
Okay. And where y'all getting married? Okay. What is they stated? Congratulations. Good luck.
Yes.
You.
Yep.
I'll probably be, yeah, I'm not in here. All right, guys, let's chat real quick. So, we have a wedding obviously coming in a second, but, let's see, so what did the number 2 case say about, we just said that they have to go to trial. What did they say?
I tried to email them, they didn't respond. I mean, I tried to call them, but the number's no good. So I did send my email and I did let them know that the continuance was denied. I did speak with a plaintiff side attorney and they said they're ready and it's gonna take 2 days.
Okay, 2 days, okay.
Uh-huh. And we lost a couple. The state of Texas settled last night. And the Capel lodging for DCAT, the plaintiff is requesting for a continuance. And Children's Park Learning Center versus DCAT, they settled. So we have. Do you want me to count the Couture hotel? Because they're supposed to be settling, but
I know
they
they're
might not.
supposed, well, they're supposed to be getting us dismissal paperwork. Let me see if they have.
They said they would try to get it today, if not, it'd be
So
Monday.
what we're doing right now is we have a docket for next week, and so we're trying to figure out what is still around on the docket. Let me see if I can